Three major immigration reform bills have just passed the United States House of Representatives, and they could completely change the future for millions of people living in America. These bills affect border security, green card backlogs, work visas, deportation rules, and even a possible legal pathway for certain undocumented immigrants. If you live in Texas, these changes will impact you more than almost anywhere else in the country. Families waiting years for visas, workers stuck in endless backlogs, dreamers hoping for stability, and undocumented parents worried about deportation. All of them could see their lives reshaped by what just happened in Washington? But here is the critical question. Do these bills help you, hurt you, or put you at risk? And more importantly, what should you be doing right now to protect yourself and your family? In the next few minutes, I'm going to break everything down in clear, simple language so you know exactly where you stand, because the decisions made over the next few months could determine your immigration future for years to come. Hi, I'm Timothy, and I'm here to guide you through these fast-moving immigration changes step by step. My goal is to take complicated legal and political updates and explain them in a way that actually makes sense for real people. Today, I'm going to walk you through the three immigration bills that just passed the House of Representatives, what each one contains, who benefits, who faces new risks, and what still has to happen before any of this becomes law. I'll also share practical actions you can take right now so you're prepared instead of caught off guard. Some of these changes could open new doors for you, while others could create serious challenges depending on your situation. That's why understanding the details is so important. By the end of this video, you will know exactly how these proposals could affect your visa, your green card process, or your legal status, and what your smartest next move should be. Let's start with the big picture of what just happened. This week, the House of Representatives approved three separate immigration reform bills after months of intense debate and negotiation. For years, immigration policy in Washington has been stuck in political deadlock with both parties, unable to agree on major changes. That's why this moment is so significant. Seeing three large immigration bills pass the House with bipartisan support is something many experts thought was almost impossible in today's divided political climate. But passing the House is only the first step in a long process. These bills still have to go to the Senate, where the debate will be even tougher. They also need presidential approval before they can become actual law. So, nothing has changed yet in real life. No new rules are active today. But what happened this week shows the direction immigration policy may be heading in 2026 and beyond. And that direction is powerful, complicated, and in some ways contradictory. One bill focuses heavily on border enforcement and deportation rules. Another expands legal immigration and reduces backlogs. And the third creates a possible pathway to legal status for certain undocumented immigrants. Together, these three bills represent the most serious immigration reform effort in more than a decade. Understanding each one clearly is essential because your future could depend on which of these proposals eventually becomes law. So let's break them down one by one in plain, simple language. The first bill is called the Secure Border and Interior Enforcement Act of 2026. And this is by far the toughest and most enforcement-focused of the three proposals. The main goal of this bill is to dramatically expand border security, increase immigration enforcement, and make the consequences of illegal entry much more severe. It authorizes an enormous $32 billion in new funding over the next 4 years, most of which will be spent directly along the southern border. That includes $12 billion specifically for new wall construction and barrier reinforcement in Texas, Arizona, New Mexico, and California. Another $8 billion would go toward advanced surveillance technologies such as drones, cameras, sensors, and monitoring systems. And the final $12 billion would be used to hire and train thousands of new enforcement officers. Under this bill, the federal government would add 15,000 new Border Patrol agents within the next 3 years and 8,000 new immigration and customs enforcement officers. Large training facilities would be built in Texas, particularly in the El Paso and Rio Grande Valley regions. For communities across Texas, this would mean a much stronger and more visible federal enforcement presence, not only at the border but also inside cities and towns throughout the state. One of the most dramatic changes in this bill involves the way asylum claims are handled. Right now, many people who arrive at the border and request asylum are allowed to enter the United States while their cases move through the immigration court system. This bill would largely end that practice. Instead of being allowed inside the country, most asylum seekers would be held in processing centers outside the United States, either in Mexico or in third countries that sign agreements with the U.S. Only after passing an initial credible fear interview would they be permitted to enter while their cases continue. Supporters of this change say it will reduce fraudulent asylum claims and discourage illegal crossings. Critics argue that it could put vulnerable people in dangerous situations and make it much harder for legitimate refugees to seek protection. Another major part of this bill is a push for much faster immigration court proceedings. It requires detained immigration cases to be completed within 6 months and non-detained cases within 12 months. On paper, that sounds like a good thing. Faster decisions mean less uncertainty. But immigration advocates warned that these strict deadlines could make it extremely difficult for immigrants to find attorneys, gather evidence, and properly present their cases. Perhaps the most controversial section of this bill is the expansion of deportable offenses. Under current law, only serious crimes such as aggravated felonies or crimes of moral turpitude usually trigger deportation. This new bill creates a broader category called crimes affecting public safety. That category would include DUI convictions, domestic violence misdemeanors, certain drug possession offenses, and even repeated traffic violations. And here is the part many people don't realize. These rules would apply not only to undocumented immigrants, but also to lawful permanent residents. In other words, even green card holders could suddenly face deportation for offenses that previously would not have put them at risk. Imagine someone like Juan in Houston, who has lived legally in the United States for more than a decade. Years ago, he made a mistake and was convicted of a single DUI. He paid his fines, completed probation, and moved on with his life. Under current rules, that one mistake would not normally threaten his green card. But under this new bill, that same DUI conviction could be enough to place him into removal proceedings. He would suddenly have to fight to stay in the country he has called home for most of his life. Stories like his show just how serious and far-reaching this enforcement bill could be for millions of immigrants across Texas and the entire nation. If everything you've heard so far feels overwhelming, you're not alone. Immigration law is already complicated, and these proposed changes make it even more important to stay informed. That's why I want to pause for just a moment and say this. If this breakdown is helping you understand what's happening and how it could affect your life, take a second to stay connected so you don't miss future updates. Immigration policy in 2026 is moving fast, and being informed in real time can make the difference between making the right decision and being caught by surprise. My goal is to keep explaining these changes clearly, honestly, and without confusion, so you always know where you stand. Now, let's move to the second bill, which is almost the complete opposite of the first one. While the first bill focuses on enforcement and border security, the second bill is designed to fix and modernize the legal immigration system. It is called the Legal Immigration Reform and Backlog Reduction Act of 2026. And for millions of people waiting years for green cards and visas, this proposal could be life-changing. The main purpose of this bill is simple: reduce delays, expand legal immigration opportunities, and make the system work more efficiently for families and skilled workers. One of the biggest changes in this bill is the elimination of per-country caps for employment-based green cards. Right now, immigration law limits how many green cards can be issued to people from any single country in a given year. Because of this rule, highly skilled workers from countries like India and China face incredibly long wait times, sometimes 10, 15, or even 20 years before they can receive permanent residency. This bill removes those caps entirely. Green cards would be issued based on priority date instead of country of birth. For hundreds of thousands of people stuck in endless backlogs, this change alone could dramatically shorten their wait times and finally allow them to move forward with their lives. The bill also increases the total number of employment-based green cards available each year. Right now, only 140,000 employment green cards are issued annually. Under this proposal, that number would rise to 250,000. And if demand continues to exceed supply, the cap would automatically increase even more in future years. This is a major recognition of the reality that the American economy needs more skilled workers in fields like technology, healthcare, engineering, and science. For states like Texas, where companies in cities such as Austin, Dallas, Houston, and San Antonio rely heavily on foreign talent, this expansion could have an enormous positive impact. Family-based immigration also sees significant changes under this bill. The annual limit for family preference visas would increase from 226,000 to 350,000, allowing more families to reunite legally each year. A new fast-track system would be created specifically for parents of adult U.S. citizens, promising processing times of around 12 months instead of the long delays many families face today. But not every change in this bill is good news for everyone. In order to free up more visas for other categories, the bill completely eliminates the sibling sponsorship category. That means U.S. citizens would no longer be able to file new petitions for their brothers and sisters. Anyone who has already filed would be protected under a grandfather clause, but after the law takes effect, no new sibling applications would be accepted. For communities that relied heavily on this pathway, especially Filipino and Mexican families, this would be a painful loss. Another important part of the bill deals with the diversity visa lottery program. In the past, some lawmakers wanted to eliminate the lottery entirely. This proposal takes a middle path. The program would continue, but the number of visas would be reduced from 50,000 per year to 30,000, with the remaining visas redirected to help clear family-based backlogs. The bill also creates a completely new opportunity called the Startup Entrepreneur Visa. This would allow foreign nationals who start businesses in the United States create jobs and generate revenue to obtain legal status and eventually a green card. The goal is to attract innovators, investors, and entrepreneurs instead of losing them to other countries. In addition, the entire visa processing system would be modernized. USCIS would be required to move toward full electronic filing, online case tracking, and digital interviews. Premium processing would be expanded to nearly all visa categories, allowing applicants to pay for faster decisions. Some critics say this creates a two-tiered system that favors wealthier applicants, but supporters argue that the extra fees will help fund faster processing for everyone. For many legal immigrants, this second bill represents hope after years of frustration. People who have built careers, bought homes, and raised families in the United States while waiting endlessly in line could finally see real movement. Employers would be able to keep talented workers instead of watching them leave the country because of visa delays. In Texas, especially where industries like technology, energy, and medicine depend on global talent, these reforms could strengthen the economy and create new opportunities. But as positive as this bill is, it still does not address one huge group of people. Millions of undocumented immigrants currently living in the United States. And that brings us to the third and most politically sensitive bill of all. The third bill is the one that has created the most emotion, debate, and attention across the country. It is called the Earned Pathway to Legal Status Act of 2026, and it directly addresses the situation of millions of undocumented immigrants currently living in the United States. Unlike the first bill, which focuses on enforcement, and the second bill, which focuses on legal immigration, this proposal is designed to create a structured and conditional way for certain undocumented immigrants to come out of the shadows and eventually gain legal status. But it is extremely important to understand what this bill actually does and what it does not do. This is not an amnesty program. It does not grant immediate green cards. It does not provide instant citizenship. Instead, it establishes a long, strict, and highly controlled process that applicants would have to follow for many years. To qualify under this program, an undocumented immigrant would need to meet several specific requirements. The first and most critical rule is the residency requirement. You must prove that you have lived continuously in the United States since January 1st, 2020. That date is the official cutoff. Anyone who entered the country after that date would not be eligible at all. Second, you must have a clean criminal record. The bill states that anyone with a felony conviction or more than 2 misdemeanor convictions would be automatically disqualified. Third, you must show that you have been either continuously employed, enrolled in education, or serving as a primary caregiver for a dependent. Fourth, you must pass full background checks and biometric screening. And finally, you must demonstrate basic English language ability and knowledge of U.S. civics. Only people who meet all of these conditions would be allowed to apply. If you qualify, the first step would be to apply for something called conditional resident status. This is not a green card. It is a temporary legal status that would last for 8 years. During those 8 years, you would be allowed to live and work legally in the United States. But you would have to follow very strict rules. You would need to maintain steady employment or education, pay taxes every year, avoid any criminal trouble, and check in regularly with immigration authorities. If you fail to meet any of these requirements, your conditional status could be taken away. Only after successfully completing the full 8-year period would you be allowed to apply for lawful permanent residence, which means a green card. And only after holding that green card for 5 additional years could you finally apply for U.S. citizenship. So from start to finish, the total path from undocumented status to citizenship would take at least 13 years. The bill does include special provisions for Dreamers, the young people who were brought to the United States as children. If you entered the country before your 16th birthday, have lived in the U.S. for at least 10 years, and have graduated from a U.S. high school or obtained a GED, you would qualify for an accelerated process. Dreamers would be able to move from conditional residence to a green card in 5 years instead of 8, cutting the total timeline to citizenship down to about 10 years. This is one of the few parts of the bill that has broad support from both political parties. But qualifying on paper is only the beginning. The biggest challenge for many applicants will be proving that they actually meet the requirements, especially the continuous residence rule. The bill requires extensive documentation to show that you have been living in the United States since January 2020. Acceptable evidence would include rental agreements, mortgage statements, utility bills in your name, bank statements, employment records, pay stubs, tax returns, school records, medical records, and sworn affidavit from people who can confirm your presence. For immigrants who have lived quietly, paid rent in cash, worked in formal jobs, or moved frequently, gathering this level of proof could be extremely difficult. Many undocumented families do not have years of official paperwork, and without it, even eligible people could struggle to be approved. The financial cost of this program would also be significant. The initial application fee for conditional residence would be $2,000 per adult and $1,000 per child. After 8 years, the application to adjust to permanent residency would cost another $2,500 per person. Then years later, naturalization fees would add even more. When you add everything together, a family of 4 could easily spend more than $15,000 in government fees alone over the course of the process. And that does not include attorney fees, document translations, medical exams, or other expenses. For many low-income families, these costs could be one of the biggest barriers to participation. There is another restriction that many people do not realize. While in conditional resident status, applicants would not be allowed to receive most federal public benefits. That means no Medicaid except for emergencies, no SNAP food assistance, no federal housing aid, and no Affordable Care Act subsidies. Even though applicants would be working legally and paying taxes, they would not have access to the social safety net if they faced financial hardship. Only after receiving a green card would they become eligible for those programs. And even then, normal waiting periods would apply. In Texas alone, there are an estimated 1.7 million undocumented immigrants. Experts believe that if this bill becomes law, somewhere between 800,000 and 1 million people in Texas could potentially qualify based on the January 2020 residency requirement. Cities like Houston, Dallas, Fort Worth, Austin, and San Antonio have huge communities of immigrants who have lived here for many years, raised children, and built their lives. For them, this bill could offer a real chance at stability and security. But it will not be easy. The process is long, expensive, and full of strict rules that will leave many people excluded. Think about someone like Rosa in San Antonio. She entered the United States in 2018 with her 2 children and has been working hard ever since. She pays rent, her kids attend public school, and she has stayed out of trouble. On paper, she would qualify for this program because she has been here since before 2020 and has no criminal record. But proving it will be her biggest challenge. She has moved apartments, worked different cleaning jobs, and was often paid in cash. Some of her former landlords may not remember her, and some employers may be hesitant to provide letters. To build a strong application, she will need to track down years of documents, contact old supervisors, gather school records, and possibly hire an immigration attorney she can barely afford. Her story shows both the hope and the difficulty built into this proposal. Now, after hearing about all three bills, the obvious question is this: what happens next? Passing the House of Representatives does not mean these proposals automatically become law. The next and most difficult stage is the United States Senate, and the political reality in the Senate is very different. Unlike the House, where a simple majority is enough to pass legislation, most major bills in the Senate require 60 votes to overcome a filibuster. Right now, the Senate is narrowly divided, and immigration remains one of the most controversial issues in American politics. Several different outcomes are possible. The Senate could approve these bills exactly as they are, though that would require strong bipartisan support. The Senate could rewrite large portions of the bills, adding new provisions, removing others, or combining them into one larger immigration package. It is also possible that only one or two of the bills move forward while the others fail. And of course, there is always the chance that none of them reach the 60 votes needed and the entire effort collapses. Even if the Senate does pass them, the president must still sign them into law, and negotiations between Congress and the White House could lead to additional changes. In other words, what you have heard so far is not the final version. It is the starting point of a long political process. Even if these bills eventually make it through the Senate and receive presidential approval, real change would not happen overnight. Immigration law does not switch on like a light. After any bill becomes law, federal agencies must translate the legislation into detailed regulations and procedures. USCIS would need to design new application forms, build updated computer systems, train thousands of employees, and create step-by-step guidelines explaining exactly how the new rules will be applied. That process alone can take many months. For example, the Conditional Residence Program for undocumented immigrants would almost certainly not begin immediately. Experts expect it would take at least 8 to 12 months after final passage before applications could even be accepted. Border enforcement provisions would also roll out gradually as funding is allocated, new officers are hired, and facilities are constructed. Changes to visa categories and green card processing would require major technical updates and staffing adjustments. So even in the best-case scenario, the effects of these bills would unfold slowly over time. Because of that reality, the most important question is not only what might happen in Washington, but what you should be doing right now. The smartest move is to prepare as if at least some of these proposals will eventually become law. If you are undocumented and believe you could be eligible for the Earned Pathway program, the time to start getting ready is today, not after the law changes. Begin collecting every possible document that proves you have been living in the United States since January 2020. Look for old leases, rent receipts, utility bills, school records, medical records, pay stubs, bank statements, church or community letters, and anything else with your name and a date on it. Even small pieces of evidence can become important when put together. Organize everything in chronological order and keep copies in a safe place. Many people make the mistake of waiting until a program opens before gathering documents. By then, it can be too late to track down old paperwork or contact former employers. Preparing early could give you a huge advantage. Taxes are another critical piece of preparation. If you have been working in the United States using an individual taxpayer identification number, make sure you file your tax returns on time and keep copies of everything. Tax records are some of the strongest proof of continuous presence and good moral character. If you have not been filing taxes in the past, now is the moment to speak with a knowledgeable tax professional and begin correcting that situation. Even if some of your income was paid in cash or off the books, there are legal ways to document your work history without creating unnecessary risk. Future immigration applications will look very closely at tax compliance, and ignoring this issue could seriously hurt your chances. Staying out of legal trouble has never been more important than it is right now. With the proposed expansion of deportable offenses and strict eligibility rules for the Pathway program, even a minor criminal issue could destroy your opportunity. Avoid any activity that could lead to arrests or charges. And if you have old cases on your record, obtain certified court documents showing exactly how they were resolved. Having clear proof that a case was dismissed or reduced could make a big difference later on. If you are currently in the United States on a temporary visa, be extremely careful to maintain your legal status. Do not overstay your authorized period. Do not work without proper authorization. And always keep your address updated with immigration authorities. The enforcement bill expands penalties for even small violations, and falling out of status now could create serious problems for future applications. This is also not the time to make risky travel decisions or assume that pending legislation will automatically protect you. For workers who are stuck in employment-based green card backlogs, especially those from India or China, the second bill offers real hope. But until it actually becomes law, nothing is guaranteed. Do not quit your job, abandon existing applications, or make life-altering decisions based on proposals that are still being debated. Continue following your current immigration strategy while carefully monitoring new developments. If you are a U.S. citizen who has been planning to sponsor a brother or sister, there is one action you should consider immediately. Because the sibling category could be eliminated, filing an I-130 petition now could protect your family member under the grandfather clause included in the bill. Waiting too long might mean losing that option forever. Another extremely important warning needs to be said clearly. Whenever major immigration reform is in the news, scammers and fraudsters appear almost instantly. They promise guaranteed approvals, claim they can get you on secret waiting lists, or offer to file applications that do not even exist yet. Be very careful. Until a law is officially passed and real government forms are released, no one can file anything on your behalf. Only work with licensed immigration attorneys or properly accredited representatives. Never pay large cash fees without receipts. Never sign blank forms. And never hand over your original documents to someone you do not fully trust. Finally, if you are an employer who relies on immigrant workers, now is the time to start planning ahead. The legal immigration reforms could open new opportunities for hiring and retaining talent, but they will also require quick action once the rules change. Reviewing your current workforce, identifying employees stuck in backlogs, and speaking with Immigration Counsel early could help your business move faster when new options become available.